All right, in this video, we're talking about the latest development in the Tory Lanez case. As soon as I heard about this news, I really just wanted to get in front of the camera and talk about this case because this is a very rare situation in which we have an opportunity to hear about what the thoughts of the lawyer was about the actual case. The way we got here was basically, you know, that Tory went to trial, he got found guilty, and he had new counsel come on, and they ended up filing a motion for a new trial, but they also ended up blaming his previous counsel. So current counsel is Jose Baez and Matthew Barhoma, and they both basically said that his prior counsel, Sean Hawley, rendered ineffective assistance of counsel. If your lawyer has fallen below the reasonable standard of what a lawyer should do, and you are somehow prejudiced by that ineffective assistance, in other words, but for the lawyer's errors, you might have had a different or more favorable outcome, then that can be grounds for you to be able to attack the underlying conviction. And that's whether you went to trial or even if you ended up pleading guilty. If on some level it's then exposed that your lawyer rendered ineffective assistance of counsel, that can be grounds for you to be able to withdraw a guilty plea. So when you then go to court and you say, hey, my lawyer messed this up, or my lawyer, did a bad job, and so I want to have this conviction overturned, or I want my plea withdrawn, then you're going to file your motion saying the ways that you feel like they messed up. And part of that ends up being that you waive attorney-client privilege. So typically all communications between an attorney and their client are privileged and, can never be revealed. But if you are then saying that, hey, my lawyer rendered ineffective assistance, that then opens up, you have to then explain the conversations and things that were told to you, things you told to your lawyer, and then the judge is going to look at the information to determine whether or not the attorney rendered ineffective assistance, and number two, whether you were prejudiced by said ineffective assistance. And so as part of the analysis of this case, the email communications between Sean Hawley and Tory Lanez were turned into the court, and then those were later unsealed by the court and they made their way onto the internet, and here we are. So first of all, shout out to Megan Cuniff, who did an article on this story, and as soon as I saw, man, we're about to see the emails between Tory Lanez and his prior defense counsel, this again just, raised my eyebrows. This is very fascinating because the reality is a lot of lawyers end up getting challenged. A person doesn't like how their case turned out and they may file a motion to withdraw a plea, or as part of their appeal or subsequent trial motions, they may say, hey, my attorney rendered ineffective assistance. But the reality is most of those people, or 99% of those people, are not famous, so it doesn't make news headlines, and so there's just no analysis such that we would ever have an opportunity to see this stuff. But because Tory Lanez is famous and that thereby garnered attention that otherwise wouldn't be drawn to a shooting case like this, this is why we have this here. This email is from Sean Hawley to Tory Lanez, and George McDezian, the trial lawyer who represented Tory Lanez at trial, was CC'd on it. And so she says, Tory, as we discussed on Saturday, I am not comfortable advancing the Kelsey defense, primarily because I don't find it to be a viable strategy. I don't believe my position will change unless Quan, that was the driver, the bodyguard, unless Quan is persuasive in the preview of his testimony, and you, so you, Tory Lanez, are persuasive under mock cross-examination by George and or Lisa. Even if both of those benchmarks, Quan /you, were to be satisfied, I am still not certain that I would be willing to go forward. In light of that, you should discuss with George his willingness and ability to move forward with that defense, and if he can do so by the trial date, which was December 6th. I will help him get up to speed if that's something that you and he are interested in. All best, Sean. I'll lead with this. We as defense attorneys, we're competitive people. We want to win. We want to do right by our clients, and especially if you're retained counsel versus a public defender, and trust me, public defenders want to win too. But in terms of retained counsel, where a client is paying you thousands of dollars to represent them, first of all, it's important to understand that you're not paying for a particular result. In other words, a lawyer can't sell you a result. If a lawyer makes any sort of promises as to the outcome of the case, that number one would be a lie, right? Because we are not God. We do not have a magic wand. We cannot predict the future. We do have, at a certain point, you have years of experience. You've seen a lot of cases, and you can have an idea as to how a case will play out, how strong your defense is, how strong the prosecution's case is, and be able to give informed, educated opinions based on that. But in terms of how the case specifically is going to turn out, you don't know, or we don't know as attorneys. And if a lawyer gives a guarantee, so, hey, you pay me 10 grand and I will make this go away. You pay me $20,000 and we will dismiss this case. I guarantee you we'll make the case go away. If a lawyer does that, then that not only is a straight up lie, but number two, it is grounds for discipline, including potentially losing one's license. So when you hire an attorney, obviously you are hoping for the best, right? Especially if you're paying top dollar for an attorney, you definitely want them to perform. But if the lawyer is ethical, they're going to make it abundantly clear that they're going to do everything that they can in order to get the best possible result in the case, but they're not able to promise any particular outcome. In the beginning of the representation, even before the representation, the client is going to have made a consultation, and they're going to talk about what ended up happening that led to their arrest or led to them facing criminal charges, right? And so the lawyer is going to have an understanding of what the case is about and might even have a light idea of what this defense strategy will be moving forward. But the reality is you really don't know the direction the case is going to go in until you really get in there, right? So once the client decides to hire and you can really have a more long and drawn out discussion about the case, about the facts of the case, going into any evidentiary issues, looking at witness statements, reviewing videos, reviewing photographs, having your investigator go out and get statements and do all of that stuff. That's when you can have a much better understanding in terms of how strong the prosecution's case is, how strong any defenses are, and what you need to continue to develop in order to get the best possible result for your client. So putting it in the context of this case, in Tory Lanez's case, we know that ultimately at trial, Mr. McDezian and the defense team put forth basically what we'll call the Kelsey defense, because that's what is referred to in these emails. Essentially, they sought to blame Kelsey for having shot Megan Thee Stallion, right? So if anybody shot her, it was not Tory, it was Kelsey. That was the defense theory. Daystar Peterson did not shoot Megan. The prosecution's not going to be able to prove beyond a reasonable doubt that Tory Lanez shot Megan. In fact, it was somebody else that shot her, and that was Kelsey, right? And there was the whole story behind that. The stakes are high when it comes to criminal cases, right? And so there's an element of self-preservation that sometimes emerges in which a client will put forth these different theories and things that they think will help the case, right? And we welcome that, right? We definitely want a client to be invested in their defense. We don't want it to be one-sided where you feel like, hey, I paid you the money, you take care of it, it's got nothing to do with me. No, we need you to be a part of reviewing evidence with us, telling us who our investigators should go out and speak to, pointing out the lies in a witness statement, pointing out the exaggerations, telling us, no, it didn't go down this way, it went that way. So defending a case is a very interactive process. But sometimes, and oftentimes, for example, one thing that comes up is a client will say, hey, well, they never read me my Miranda rights. And, people think that, okay, well, the cop violated my Miranda rights, never read me my rights. That should be a grounds for the judge to throw out the case, right? Not knowing that, yes, there is, Miranda rights and police are supposed to read you your Miranda rights prior to engaging in a custodial interrogation. But just because a cop violates Miranda doesn't mean that, the judge is just going to throw your case out. There's evidentiary issues in terms of whether any statement that you gave in violation of Miranda would end up going in front of a jury, right? So that would be an issue to determine whether that evidence gets thrown out or not. But it's not a, part of a motion to dismiss where, hey, the cops, failed to read you your Miranda rights. They got a statement from you. That's a violation. Okay, the judge throws out the case. That's not the case. And that's part of the education process as well. It's not only our duty to, vigorously and zealously advocate for our client. It's also our job to educate our clients on the law so they can understand what the law says and how it applies to the case and, all those different things. So that's an example. So Miranda would be an example. There could be things that they think should be admissible at trial if a case were to go to trial. For example, I had a case where my client was alleged to have violated a protective order a whole bunch of times, right? So there were like 15 to 20 alleged protection order violations. Now listen, and this is a side note, if you are ever served with a protective order and you're prohibited from calling the person, texting the person, emailing the person, being within a certain distance from that person, that's not optional, right? That is an order and you have to abide by it. If you don't, then that can be a misdemeanor charge, right? And you can go to jail for it. Typically, it's not going to be something you go to jail for, but you can, especially if there are numerous violations and they become more egregious and the like. But my client was alleged to have violated this protective order numerous times. And one of the things that he wanted to advance was that, his girlfriend had this terrible character. She was a liar. She was she was promiscuous. Let's put it that way. She had a bad reputation and all these different things that he wanted to be able to, if the case went to trial, he wanted to be able to testify all that and air out her dirty laundry and all this kind of stuff. And what I had to help him understand was that honestly, none of that stuff is relevant at all. At the end of the day, as we looked at the evidence, which were some of the text messages, some of the emails, some of the phone calls, all the prosecutor is going to say is, hey, look, ladies and gentlemen of the jury, look at all these text messages, on this date, on Monday, on Tuesday, on Saturday, on the next Sunday. Here's these emails, here's these calls. He violated this protective order that was in place. And so therefore he's guilty. And so you're wanting to air out all the dirty laundry and throw your ex-girlfriend under the bus. None of that stuff is really going to be admissible. So he had to be made aware that that was just not going to be a viable defense. And sometimes clients get frustrated or upset when they present to you these ideas that they have for the defense, and you have to politely and respectfully, shut it down to let them know. And I'll never just shut something down without explaining why. And I'll never, at least I try not to come off as condescending at all. I certainly, at the end of the day, there's a customer service element to what we do. And so, even if the answer is obvious to me, I want to make sure that they understand, okay, this is why this isn't going to work. This is what the law says. These are what the facts are. And so this is why this isn't going to work. As frustrating as that may be for the client, they do need to understand that, right? I can't give them false hopes either. So if I tell them, oh yeah, you want to bash your ex-girlfriend in court and, air out all the dirty laundry. Yeah, that'll work. Yeah, we totally, the jury's going to side with you and they're going to want to go after her. And so they're not going to convict you. If I do that, number one, that would be ineffective assistance of counsel, right? That would be terrible advice. We would go to trial. We'd be sure to lose. And then the client would be mad at me because I didn't keep it straight with him when he advanced or he brought forth a theory that really wasn't viable. So with that kind of as a background, there's, again, clients and their self-interest in not being convicted. They're going to do and say everything that they can in order to arm their attorney with information in order to help them get the case dismissed or get charges dropped or reduce the sentence or whatever the situation is. But what you have to understand is we as lawyers, and I think one of the issues that comes up, at least here, is the idea, and we're going to talk about, this email again, a lawyer cannot suborn perjury. And what does that mean? Basically, it's presenting testimony or a declaration or both to a judge or a jury that the lawyer knows to be false. So as a lawyer, you cannot put information you know to be false in front of a judge or a jury. We just can't do that. That's number one. And then the other thing is going to have to do with just the lawyer's reputation. Again, we want to fight hard for our clients. We want to get a great result for our clients. We want our clients to be happy on the other side of the representation and feel thankful that they decided to move forward with us. We want all those things, right? But at the same time, we have a reputation to uphold. And if you see that a client wants to move a defense in a direction that you as a professional don't agree with, then you have to let the client know. And I think we have a combination of those two things here in this email. So when Ms. Holly tells Tory in this email, hey, I'm not comfortable advancing the Kelsey defense, right? So she's telling him, hey, if you want to move forward at trial and blame Kelsey, I'm not comfortable with that, right? And so Ms. Holly has had the benefit that none of us have, right? Of sitting across the table from Tory and going through the evidence with him and looking at the witness statements, looking at Meg's statement, looking at Kelsey's statement, looking at any other witness statements, all the evidence. And when Tory presents to her this idea that, hey, Kelsey did it, she's saying, hey, after I've spoken with you, after I've gone through all the evidence, I do not feel comfortable going forward with this defense, right? I don't find it to be a viable strategy. The lawyer has a duty to let their client know that, hey, this thing that you want to push forward is not going to be successful in court. If we put this in front of a jury, it's not going to work, right? The lawyer doesn't do their client any favors whatsoever by putting forth something that they know is just not going to work. She goes on to say, I don't believe my position is going to change unless Quan is persuasive in the preview of his testimony. So one of the things that you'll do when you have a witness that you think you might be able to use at trial is get a statement from that person, right? So whether it's in the presence of the lawyer or not, one way or the other, you're going to have the investigator take the statement. The lawyer is not going to take the statement because if for whatever reason that witness goes sideways, so they said the light was red when the car went through the intersection, and then the next day they say, no, the light was green. You want to already have had a third party locked him in and heard him say, no, the light was red, right? So in case they change up their testimony, you have it documented by your investigator. The other thing is, if for whatever reason that witness becomes unavailable, then you have your investigator who can testify as to what that witness told them. If it was just you, the lawyer, who got the statement, now you as the lawyer have to become the witness, and you can't be a lawyer and a witness. So that's why you always want to have, a third party taking your statement. So what she's saying is, hey, unless Quan is persuasive, so Quan would basically have to convince Ms. Holly that he saw Kelsey shoot Megan. So Ms. Holly would have to be satisfied that whatever Quan would say, she would not be suborning perjury, right? So she can't knowingly present false testimony. And she knows that he's going to be subjected to cross-examination. So he's going to have to be able to withstand an experienced prosecutor cross-examining him as well. So she wanted to be able to see that. The other thing she was talking about was Tory himself being able to take the stand and say that Kelsey did it. And this is really important because we know that Tory ultimately did not take the stand. There were a few reasons for that, but I think this one was a major reason, because if he was going to take the stand, he wasn't going to take the stand and say, yeah, I shot her, right? He was going to have to take the stand and say that Kelsey shot at Meg. But the thing was, Ms. Holly wanted him to have to be able to stand up to a mock cross-examination. You want to be able to see how they're going to perform under cross-examination. You might just call up your boy, hey man, I'm putting on my client in this case. Can you look over this discovery? And then I want you to cross-examine him. I want to see how he does, right? So she wanted to be able to see that, because it's one thing for him to just say, yeah, Kelsey did it. I didn't do this. I would never do something like that. But it's another thing to have an experienced defense attorney acting as a prosecutor, confronting you on all the difficult issues, right? That defense attorney would be really trying to completely rip you apart in order to expose how strong or not your testimony is. So what she was saying was that, hey, even if, right? So for a lot of attorneys, that might be enough. Okay, well, if we can get Quan in here and he's persuasive, and then you could stand up to cross-examination, okay, boom. Now I might be good with advancing this theory. But she said, even if both of those benchmarks were satisfied, so even if Quan is persuasive, and even if you are persuasive under a mock cross-examination, I'm still not certain that I would be willing to go forward. And so that just goes to show that, in light of her review of the evidence, the witness statements, the video recordings of these interviews, and all these different things, she just didn't feel comfortable advancing this theory. And that really says a lot. It is very telling that a lawyer is giving this analysis, and even though it's just 2 paragraphs, so this next one where she says, hey, talk with George, right? So I want you to talk with George and see if he's willing and able to move forward with this defense, and if he can be ready to go by the trial date. Obviously, they ended up moving forward with this trial, and they moved forward with that defense, and ultimately the jury found him guilty. I think one of the things that probably ended up holding this case up and making a deal impossible was Tory's immigration situation, right? So obviously Tory gets a lot of money here in the United States, and living here, I mean, however much he loves being in the United States versus his home country of Canada, if you are not a U.S. citizen, then any situation, even if you had a green card for 20, 30 years, I just know this because I practiced immigration law for over 10 years. If you are a green card holder and you get accused of a crime, then the red flags go up, because you really need to be careful, because you are always at risk of possibly being deported if you have any criminal issues and you're not a U.S. citizen. So for him in particular, the thing that would have been really challenging is if you have a crime of violence and you have a sentence that's either a year or more on that crime of violence, then that's what's considered to be an aggravated felony. And that's basically the worst thing you could have under immigration law. And his deportation essentially would have been guaranteed. And so I imagine that any deal that the prosecutor would have been interested in would have involved, one of these crimes of violence and a sentence that would exceed a year. And so Tory Lanez, by signing a deal for any of that stuff, would basically be signing his deportation. And that was just, not an option. But the difficult thing is, if you don't sign such a deal, then that means you're going to trial, right? Because once you get charged with a crime, there's, 3 ways out, basically. The case gets dismissed, and that obviously wasn't going to happen here. Or you reach a plea agreement with the DA, or you go to trial. And so he decided to take his case to trial, and we saw what happened after that. There are other arguments that the defense made in terms of the DNA evidence, and they made some accusations against the prosecutor. But I felt like this one was the really meaty one that I wanted to sink my teeth into, because it's just one of those rare occasions. We might not ever, see another situation like this again. The stars just really aligned, it being, a big Hollywood case, and then having this attorney issue that we see this. But I'm curious as to, anybody who, really thought that Tory Lanez was wronged or Tory Lanez was not guilty or anything like that, how much this, changes your perception. Because listen, I don't know who Miss Holly is, but I know she's been practicing law a long time. She obviously has a vested interest in, in doing right by her client and doing, practicing to the best of her abilities. And for her to have gone through the evidence with her client, sat down and talked to him about the case, probably talked to other people about the case, and ultimately this late before trial, saying that, hey, I'm not comfortable putting this forward. That just is really, really telling. So what are your thoughts on this? I mean, do you put any stock in what the attorney is saying, or do you still think that Tory Lanez didn't do it? You still think that Tory Lanez should not have been found guilty? Or do you think that, the what happened is exactly what should have happened? I'm curious as to your thoughts, and let me know if there's some other angle that you would like me to address in this case, because it's a pretty interesting one. Well, just going to cut it off right there. So if you got something out of this video, please show me some love. Hit the like button. Make sure you subscribe to the channel and turn on those notifications so you never miss a new video when it drops. And as always, I want to thank you so much for watching. And until next time, peace.